We just want to know what your name is, whether or not you're an attorney, and if you have a burning question that caused you to come downtown on a Tuesday, beautiful Tuesday night. Okay? So why are you here? What question do you want answered? Okay? Michael is no longer chewing, so you can start.
I'm Michael Nicholson. I'm not an attorney. I don't have a burning question. I'm looking for your tell me how to fix that.
Okay.
Cookie Levitz, an attorney, and what he said.
Okay.
Mark Mayer, I am an attorney, and I'm just looking for a little more perspective in dealing with attorneys and mediations.
Okay. So we don't have to answer any questions tonight. That's
Great.
good. Okay.
My name is Diane Gregg. I am not an attorney. The first case that I ever mediated, one of the parties was an attorney. And I'm here just to soak up all the information I can.
Excuse me, I'm Adrian. I'm a non-attorney. And I guess my major question would be, how do you, it's almost personal, how do you set yourself up for being respected? They know more about, or they do maybe know more about the law.
So how do you set yourself up to be respected? Okay, if we don't answer that before the end of the night, please ask us again. Okay, Cassie?
I'm Kathy, I'm a non-attorney, and I don't have a burning question, but I think Adrian's question is a great one. And I just feel like that's always an area that I can improve in, so I'm just here to learn.
Okay.
Rebecca Zuber, I'm not an attorney. My question may be a little bit part of Adrian's. I want to know how to move, when you've got one that's being an advocate and they're stonewalling, how you sort of can move them into a more reasonable posture. Like, you know, the guy for the car insurance company who's telling you that, you know, he doesn't have the only authority to settle that he has is what the insurance company's already offered, and, you know, there's no point in talking about it.
I don't know if stonewaller is a word, but it is.
Works for me.
Marilyn Smith, I'm an attorney. I have two kind of burning questions, and I have to meet my babysitter at 7, so I don't know if I'll get them all answered, but one is similar to Adrian and Cassie, like for CCR as an organization to respect and defend that line of non-mediators mediating in an increasingly attorney-driven environment. What does CCR need to do to build that capacity to, you know, for credibility, whatever that confidence is for non-mediators to mediate in certain situations? So that's one of the things. And the other one is more around, I guess it's also around training. How do you bring in that type of, you know, attorney as advocate, those issues and how those play out in mediation, whether you're an attorney or a non-attorney mediating, how do you deal with attorney advocates in mediation? That's something I'm curious about, how training should address that, teach that.
Okay, thank you. All right, hi.
I'm Phyllis Mandler. I'm a non-attorney. No burning questions, but there's so many attorneys we are involved with in this process that the more I can learn that would be helpful, the better.
Good. Okay.
My name is Susan Young. I'm not an attorney, and I think one question that I've had attorneys that, especially those that spoke that were really helpful, and then some that were a hindrance to the process. And is there anything that I can do that it's sort of the same thing as a stonewaller, but is there anything I can do to move them from being a hindrance to a help in the process?
My name is Stanley, and I'm not an attorney yet. And my interest in coming down here was partly to check out. I like working with attorneys in mediation. I find they can be very helpful. And I wanted to find out what I was doing right and what I was doing wrong, get a little validation. And I think the thing that I am curious about is I'm interested in exploring more. I found sometimes that it's helpful to explore the needs and interests of the attorney when they're acting as an advocate, and how other people deal with that.
I'm Bonnie Tunick, I'm an attorney.
Oh, sorry, Bonnie.
Oh, I guess I'm not anymore.
Disbarred.
Yeah, it's that easy.
You're not practicing.
Right, I'm not practicing, I'm a recovering attorney. I have lots of burning questions, but none of them have to do with mediation, so I'm just here to soak up what you have to say.
Okay.
Jim Murphy, I guess, but
You're a
maybe
super
I'm a
attorney.
recovering attorney too. I'm a judge, and we have some wonderful experiences with mediation in the 4th District in Maywood. And today's my anniversary, but Drew promised we were going out for steak dinner, so.
This is it.
Adrian makes a good point. You know, you got that table, is that party got an advantage because they're an attorney? I've always been kind of curious about that. I've taken mediation course at judicial colleges, the 40 hours, and it's very, very, it's an interesting, all those questions are good and they're all kind of related. That's what I want to find out too, is how you handle it. So, going forward.
Lynn, if I may, as I heard these comments, I would raise a question on establishing balance between an attorney party and a non-attorney party.
We'll check back with this at the end of the night and see if we've not covered it, and we'll cycle back. But I'm hoping that we will cover that. All right. I just have to remember to come over here and change the slides because I get going and okay, we did all that. Okay. One of the issues we wanted to cover is, you know, if you're a non-attorney mediator, as I am. What can you do really to establish, you know, yourself, to set yourself up for respect and that type of thing? And what I have found, I really have not found attorneys questioning me as a mediator. I probably, I'm going to say in the last 4 years or so, have probably mediated about 80 cases here at CCR. And I could tell you there maybe were 3 or 4 times when, in my opening remarks, someone had asked me if I was an attorney. And I have responded, I don't answer their question. I say I am a trained, certified mediator here at the Center for Conflict Resolution. And let it go at that, and it's never been challenged. It has never been an issue for me. So I interpret that in a way that I think it's how you present yourself. It's if you appear to be comfortable, confident, you know the process, you know what you're talking about, and you're able to adapt and shift, depending on what the personalities are of the parties. But I think it's really important to establish yourself early on in the mediation process. So right away, when you walk in the room, how you shake their hand, how you look them in the eye, you know, how you set yourself up, how you start talking. I think that's to me, that's critical. I also use the policy statement, and I think you all have seen it. I don't know if all of you, oh, I thought I had one of these. You all have seen it. No, I do have it here. It's just a bad stick. I think this can help us establish ourselves, establish our credibility as knowing what we're talking about. If you can, you know, cover what is required in our opening statement in the process here, and then basically review it. You know, here it is on paper, it looks official. You know, I think you establish some credibility right off the bat there. But I think this really helps to reinforce that, yes, we know what we're talking about.
This is probably maybe a question to put up there, or a question at some point in time. I'm just curious in terms of people's experience, if, because attorneys are being exposed to mediation more and more, especially if attorneys are coming to mediation, many of them may have been exposed to a value to mediation rather than a facilitated model. And I'm just curious if we're running into any kind of problem generally where attorneys are expecting that the mediator is going to be more evaluative, and if they aren't that experienced with the facilitated model. I just would want to hear at some point people's experiences.
Well, let's talk about that right now. Have people had experience where parties, either represented or not, attorneys or not, are expecting something different in mediation? Stanley, what have you found?
Well, I found that, I generally ask if people have had experience in mediation before, and often attorneys have. And I will usually go on to say this might be different. We employ a certain model here, and I've met some resistance from attorneys who, there was one that just happened recently, and that was there were 3 parties, and so the opening parties' initial statements took quite a while, I guess, and the attorney was patient during that. And when it was over, he said, "Okay, we've had enough of this now. Let's cut to the chase. We want to talk privately, and let's just go right to caucus before it cross country." And so that was a direct challenge to that. And what I did at that point was mediated about the process. There were 3 attorneys in the room. I said, "Is this how everybody feel?" I said, "This isn't what we normally do. It's your mediation. I'll facilitate your process, but I think there's value in doing it this way, the way in doing it in the CCR model. What does everybody else think?" And we actually, eventually, we did have. He wanted a meeting with no parties, just the 3 attorneys, because he had some revelations that he wanted to make to the other attorneys that he wasn't willing to make in the general session. And he made that revelation in private. No, I was there, and the other 2 attorneys. And I made sure everyone was okay with this first, and everybody was. It took a little while to even get there. And so we had that private, it wasn't exactly a caucus, it was sort of an odd caucus with the 3 sides through their representatives. And he disclosed what he wanted to disclose, and it didn't seem to move any other parties. And I said, "Okay." And then they started going on and talking about some substantive matters, and I said, "All right, so is this something that you really think that this sounds to me like a discussion that might be important for the parties to participate. Do you have any objection to bringing it back?"
But it sounds like it wasn't in the interest of that particular attorney that he did this, and you
And then he was patient with the
recognized
process the rest of the day after that. I mean, it seemed to
So
work.
did you do most of it in caucus or shuttle, or he was okay with the?
No, most of it was in cross-talk.
Actually,
But I think, part of what happened by letting him have that moment to try his system out was that he saw that wasn't. I guess my feeling, it didn't help any, because if that had been able to do the job, they could have done it without coming to mediation. They could have done it like a month ago.
Right.
And the fact that this case has been going on for 3 years, sure, if you think this is going to end it in 5 minutes, fine. But if it isn't, let's go back and do the process. And I think that's.
But he got it out of his system.
He got it out of his system, and then he saw that it was, he was willing. In fact, he was at the end. Thought it was a worthwhile process.
Anybody else have experience with that? Because I want to comment on it too.
Just too small of an answer. On the one, I think you have to be careful not to push people in the wrong direction. I normally tell people when they say that they have to write, that I'm I think it's best to stay together as long as possible, that's our model. But if you have a lot of experience and going back and forth, and that's what they want, we'll do it, and just think it's a better idea. And once I had someone who said, no, we're going to go to private sessions immediately after the initial statements. And the lawyer said to me, I have here a person who is, from your standpoint, a really strong person in the workplace. But if she actually gets on the witness stand, she's going to fall apart, and I don't want you to see that, so we can't have a crosswalk. It was a very good reason, a very good strategic reason for the lawyers to do that. I made another answer in the case. That's one thing. The other thing is I was once co-mediating a case where one of the lawyers was just saying we'll only talk about what's essentially the narcissistic position. That's all we're going to talk about and stuff like that. And the co-mediator was very good at one point. I could never. She just turned to her and said, "Listen, I'm running this mediation, and you will talk about it." And it worked just fine.
The lesson is go with the flow or challenge.
The answer is, trust your instincts, basically. But, I think one of the initial questions was about parties' expectations and what type of mediation is this. And what I typically do in my opening statement is I will say, I don't want to poll people, have you been in mediation before, because that may cause some imbalance in the room. Even if you've got attorneys, some attorney may have been in mediation before, the other has not. So I don't want to call to mind any imbalance. So what I say to the parties is, I don't know if you've been in a mediation session like this before, but let me explain to you the process we use here. And I work that into my opening statement. So I kind of answer the questions before they come up, so they understand. And then I kind of work pretty quickly through the opening statement, because oftentimes, especially when there's attorneys in the room, time is money. Well, that's true for a lot of people, but they're anxious to get started. And I don't want to be seen as an obstacle between them being able to say their piece. And I think that recognition that, I have something to say, and to say it concisely but clearly, I want to make sure everybody understands, and then let's move on. I think that helps establish credibility and respect right off the bat. And then I'll ask them to review the policy statement, which just reconfirms everything. So I think I like this, and I like the way it's been working. Has anyone had any experiences, positive or negative, with the policy statement? Marilyn's covering her mouth, so I don't know what
I've had a positive experience, and just like you said, it kind of reaffirms things. Just for attorneys, they like to see things in writing too, so it helps as far as that goes. And it takes care of, with an attorney, the disclosures that need to be made. So I found it very beneficial.
Yeah, and I've never had anyone not want to sign it. They just, let me sign it, let's get on with it.
Just revisiting the language, questions around the confidentiality, so there's a lot of, I'm going to call it a work in progress. This is, was adopted by the board of directors in November, and it's definitely, we're sort of trying it on, seeing how it goes, and we're going to keep reviewing it to see if it's missing anything, if it needs to be tinkered with.
Will you be looking for input from?
Absolutely. I welcome it. If somebody has a strong reaction from a party, from an attorney, from a mediator, please let me know. Questions?
Rebecca, did you have something you were going to say?
Well, I had a question, but it's not really, it's more about this than it is about what we're talking about, so I can just go and ask it.
Whatever.
Well, I was going to ask why the signature lines, because I have had people seem really reluctant to sign them. And it was actually at Maywood, where it's a short model mediation, you don't have much time. I mean, you want to talk about tearing through your opening statement. You get through that as fast as possible. And, people are often a little unsure about what they're doing back there in that room with you anyway. And when you ask them to sign a piece of paper right at the beginning, it makes them uncomfortable. I mean, that's been my experience.
And maybe more so on the short model. I haven't seen that. I used it yesterday in Skokie. Susan and I were up there. people
And
were
not
grabbing the
everybody.
pens before I had a chance to, pass it around.
I think correct me if I'm wrong, our intention was that if somebody doesn't want to sign it, it wouldn't end the mediation. So it shouldn't be like, well, no, we can't, you didn't do that, but I
Oh,
meant
no.
if it became to like, no, I'm not signing something, then you just make sure they have it. It's more to cover us that they've received it and they can't say that we didn't tell them about the confidentiality or anything. And so as long as they received it, we're establishing that pattern of practice.
And the signature line really does reflect a fairly accepted practice in
In
longer
legal
model
world.
mediations where there's an agreement to mediate, so it seems that's what
And
we
this isn't
can.
even an agreement, it's just we got it and understood it. We don't even have to agree to it.
Just one quick question, and I don't know if we would go off on, I don't want to go off on a tangent, but I always wondered about having multiple copies in the room, so parties could look at it all at the same time and not wait for the single copies.
Yeah, that's a great idea, and we've been trying to make it a practice to send it out when people come to CCR for a mediation, to send it out in advance, but having multiple copies makes sense.
Especially in the court.
Well, and one they can walk away with.
Yeah, they
People
should have
like to
a
go away
copy,
with
yeah.
something.
Okay.
What the next time?
All right. Another point about establishing yourself, I think, with attorneys, especially if you're a non-attorney mediator, and I think sometimes they understand if you are not, they just sense that. I always show a lot of respect for their professional expertise and also respect for their time. And, if an issue comes up, we'll address it right there. But I also say the same is true for any professional who might be in the room, any subject matter expert. I remember a case I had, actually it was in this room. There were a number of parties, and there were a couple attorneys, one on either side. There was the electrical contractor, the former client, and one of the expert witnesses they brought was a building inspector. Well, actually, he was a former electrical inspector for the Department of Buildings in Chicago who had retired and was now a consultant. But at the time the incident had happened, he was the inspector on the job. And he was probably my neediest person in the room to be recognized that he had something valid to say. And I mention that because I think that's often true, that if you just exhibit any type of respect for anyone who is there to share their professional expertise, they will respond positively to that. I don't know if anybody, again, if you disagree with me, let's just talk about it. Or if you've got another example. What's that? We'll mediate it. Okay. We may have a first, we'll let you know. Has anybody else had any kind of experience with that, with a professional expert or subject matter expert being with us? Okay. All right. I look for power imbalances in the room. And we touched on that a little bit. What kinds of issues have you seen with imbalance in the room? Anybody?
I was just thinking about the first case that I mediated. It was an attorney who was a landlord and his tenant. So I think that could be a real power imbalance because he is an attorney. He was a white male, she was a black female. And going back to what you said a moment ago, I absolutely agree with respecting people's professional expertise. I would add to what, not add to what you said, but confirm what you said, that every person is deserving of respect for coming to the mediation table. And so that's really how I mediated that case.
Anybody else? One thing I usually take kind of a sense of is, what kind of imbalances do I see? There's those who are represented and those who are not represented. Sometimes it's the number of attorneys on one side of the table and the numbers of attorneys on the other. The aggressive versus passive, because, we've all seen, well, maybe not, maybe I make an assumption, but I've seen attorneys in mediation who really have been more passive than aggressive and really not doing their client any favors. And another type of imbalance I've seen also is the well-prepared attorney and the unprepared. And maybe it's a last-minute substitution, a pinch hitter from the law firm. But somebody who really isn't familiar with the case. So I've seen all kinds of imbalance in the room. So I'm sensitive to that as I ask questions and as I draw out the parties.
Why do you care about that? Why are you even interested?
Because I want to make sure that the parties feel that the process is fair to them, whether or not their attorney is representing them like they thought they should have. Because
Why is that mediation?
I just want to make sure that everyone in the room feels that they've been heard.
Heard is one thing, that's just the plain, level playing field. But if there's power imbalances, I mean, why is that any of our business?
What does anybody else think? I guess I'm thinking of a particular case.
I just want to be sure we're talking about power imbalances, not just leveling the playing field.
Okay.
Not giving people opportunity to talk, we just look for leveling the playing field. But if somebody's more powerful than the other, I mean, our job is not to balance it, our job is to point it out.
I do agree to this extent that often you can have an attorney who is particularly good and an attorney who is particularly bad. There's a power imbalance there, but it's not our job to say that you're rubbish. And, I'm not saying that's,
Right.
I'm being crude in that sense, but so to a certain extent I do agree with you because that's pretty much inevitable. Also people's personal dynamics. You can have an attorney who's more aggressive than another attorney, not necessarily a good thing or a bad thing, but maybe more aggressive, intimidating the other attorney. I don't see how as a mediator it's in any way our role to, I don't see how you're going to rectify that.
And then maybe it's semantics, but I have an example I'll use in that. Go ahead, Stanley.
Well, I think power imbalance, it often exists, period. I mean, there's nothing you can necessarily do about it, but I think sometimes if the party, especially the party who is not powerful or less powerful in the situation, feels that there's a power imbalance and their recourse is to put up a wall and not move at all because they're afraid to, then it is pretty important to deal with the power imbalance that's in the middle. And I've seen it in I've seen it in fee dispute cases and I've seen it in juvenile cases. Juvenile cases especially, where you've got a kid and against them is the accuser who's got all the evidence in the world and they're pretty much, it's a pro forma, as far as the parent and everybody's concerned, it's a pro forma meeting at which you're going to determine what the punishment is going to be for the kid. And I have found occasion where pointing out that I just talking to, actually in caucus at least in one case, talking to the child about the power imbalance helped them take control rather than that this is something that's being imposed on them, that they were able to then find a way to assert themselves and have some control and some participation in the process.
What did you say that? I mean, how did you do that?
I looked at him in caucus and said, "Those sounds like this is, what kind of choices do you think you have?" And he shook his head, and I said, "Well, so you feel like what? That this punishment is just going to be imposed on you?" And he said, "Yeah." "And you're waiting to hear what it is?" And he said, "Yeah." And I said, "Well, maybe, what would happen if you took control and said what you thought might be good for you? What you said might profit you."
Well, why did you suggest a solution?
Why didn't I, or why didn't?
And was that a solution?
I didn't suggest a solution. I just asked him if he could come up with a solution that he thought he would be willing to put out there on the table that might benefit him rather than having one imposed on him by the other side.
Yeah, but
I don't think he felt that he had any choice but to agree to whatever was told.
But after you asked him that question, he might not have felt he had any choice but to put something out. It's one thing if you ask him, have you examine whether or not you want to put something out. It's another thing to say what you said. Also, there's an issue of where, I mean, if in asking the questions, your mind was to balance the power, I think that's outside our role. If in your mind asking those questions was to just help him reality test and look at his options, then I think that's exactly what we should do. A lot depends on.
Well, I think, how do you distinguish between, if you're reality testing the options, part of the options that he has are in terms of the lack of power that he might
The
have.
distinction is what was in your head when you asked them. That I can't tell you.
Well, okay. I don't know if I can draw that up either exactly.
See, I think
When you
it
talk
does get
about-
the semantics a little bit.
I think we are getting to semantics.
I just wanted to, sort of to Lynn's point, you say, is it our role to address a power imbalance? I mean, there is going to be some inherent power imbalance just in the position of the parties, but I think to Lynn's point, correct me if I'm wrong, you can correct a power imbalance during the mediation and within the context of the mediation that's occurring. And I do think a mediator has some responsibility to attempt to do that.
Well, could you explain more about that? What, I mean, in this model, we normally teach that that's outside the bound. Why?
That addressing a power imbalance.
Why would you balance power as opposed to pointing out that somebody won't follow the person? Why is it our business to balance? I don't understand.
For the process, I think, we want to make sure that the party, case in point, if a party doesn't want to talk because they feel that they are so small and insignificant and have no influence or anything. And as the mediator, one of the things that I think we can do is draw that person out and get them to talk. And by them talking, I think that in some sense helps to balance or restore a sense of balance to the process. Now, when they leave, I mean, are their positions radically altered? No, they're probably going to be, that power imbalance is still going to exist. But I think during the process.
I agree with you on that. I think we're almost playing verbal gymnastics here because the power imbalance is like what you're doing is ensuring a process that is going to help the parties move forward by drawing that person out. I think we're just becoming a bit worked up into this idea of a power imbalance, whereas I think actually what you're trying to do, and I think what Stanley was trying to do, is simply trying to move the process forward that was going to benefit all the parties.
Well, and without it being a coercive process. I mean, I think that is the responsibility of the mediator to make sure that the agreement is not something that was just coerced out of one party because they felt that they had no power.
Well, isn't it as a legitimate, a reality testing question to ask somebody why they feel powerless, as opposed to why they, as legitimate as it is to say, why do you feel it's your role to impose this on somebody else? Or, I mean, I think the answer is reality testing. I think that's where you work this stuff through.
Don't you first need for them to sort of name what they're feeling? So wouldn't you start off with, you seem quiet, what's going on? And then having them then just say, I just feel like I'm one down, and then use their words. What does one down mean? And then just go with that. So have them name it, and then go forward.
And I guess just to piggyback on you, and maybe it is semantics, because I'm thinking of that party who's shutting down, and you want to draw them out to help them express their needs and interests or emotions or whatever. And so you may look to them.
No, I don't, but that's part of the problem of what I don't want to go. If they want to be drawn out, that's fine. That's part of what she's saying. If you ask questions, and it turns out that we're going down a path where they seem to be validating that idea, yes, then, absolutely. But to go at it from the standpoint of, I'm going to draw you out whether you like it or not.
No, I'm not saying whether they like it or not. I guess in my mind, it's creating an environment where they're more comfortable participating than they were maybe 10 minutes ago. So I guess in my mind, that's what I'm thinking.
Well, I think our primary job is facilitating communication. So using the tools that we have to make people more competent communicators or more comfortable communicators, that's absolutely within the realm of what we're supposed to do.
Okay. Anybody else have anything before we move on? So I think some of what we're talking about is semantics, but again, your point well taken.
And I also think that we have to be very careful not to assume what power is. mean, I can think of, for example, a juvenile case in which it seemed, I could just watch it, it looked like the kid was powerless. But when I asked the kid, well, let's see, who did this? And the kid said, I know who did it, but I didn't do it. Well, do you know anything about graffiti? Oh, yes, I know a lot about it because I do it, I just don't do this one. And so, you know who did it, you know how it's done. Is there any way for this chaplain to avoid graffiti? The guy said, oh, yeah. I said, well, then who's the expert in this one? The kid said, I am. Now, that, I wasn't trying to empower the kid. I was trying to reality test them. Made a big difference. Because then they had a partnership as opposed to somebody trying to judge them.
Any other questions or comments before we move on?
Okay. Thanks.
Actually, I'm sorry, I did have one question. This is for the non-lawyers. When you're mediating and you feel that people are perceiving you as a mediator, what is the exact verbiage that you use to sort of say, I think you think I'm an attorney, but I'm not?
Repeat the question again.
When you're mediating, do you come right out and say, I'm not an attorney?
Only if I'm asked.
Oh, okay.
If I'm asked, and I addressed this, I think you were out of the room, in my opening statement, people may say, the attorneys may say, are you an attorney? I basically respond, I'm a trained and certified mediator for the Center for Conflict Resolution. And I have never had that be an issue. Now, you may have had other situations.
Well, I guess, no, my question, and again, maybe you answered this already, but my own thought is, if you don't mention it or anything like that, and you're mediating, and you get the distinct impression that the person believes you are an attorney, how do you correct that misperception?
Why would you correct?
What?
Why would you correct?
If they start spouting off about law and saying, well, you understand, if they say something that makes me, I've had it where an attorney says, well, you've been to law school. I can't say, just paper over that. I have to address that and say, no, I haven't been to law school.
I would address it because I think if you don't, then if it comes out, it's almost like you're, the fact that you're not an attorney doesn't mean you're any less a good mediator. So, being an attorney is a bit different, but I think if I wasn't, I would probably say I'm not an attorney because I would feel that if it then came out to a back door, they'd think, well, why didn't you tell me that at the beginning? Are you less of a mediator because you're not an attorney? That's what I know.
It's never come up for me.
I feel that when you're talking about whether or not you're an attorney, it's all of a sudden, it's about us. And if that came up in the conversation, I would just bring it back and I would say, this isn't about me. I'm not a decision maker here. I'm facilitating your discussion. I'm a trained, mediator through CCR, and leave it at that. And, because I think whether I say I am a lawyer, I say I'm not a lawyer, it's almost like it's raising or lowering my status in the room for no reason, because I don't think what my knowledge base is, other than my ability to conduct this mediation, is important. So I'm not sure I would answer it in the positive or negative.
I think that's very different if you have people without attorneys. I think if attorneys are sitting there, if I was sitting there representing my client, and I think I agree with Drew to a certain extent that maybe you talk in a language the attorneys do because they're assuming that you're an attorney and they're talking legalese, and then they find out that you're not an attorney and they think, well, hang on, did you understand half the things that I just said to you?
But what's more important is do their clients understand.
Sorry?
What's more important is do their clients understand. I would make sure that everybody in the room understands. Because they're supposed to be talking to each other.
I don't think necessarily the attorneys would. I agree with you that it
could lose your credibility.
Yes, I do agree with you. Of course it's important. The most important people are the parties. But I don't necessarily think the attorneys would always think it like that.
No, but the other thing is, if they do raise a term that you're not familiar with, how do you handle that? Well, one way is to say, can you explain to all of us in the room, when you use that term, what does it mean and how does it impact what we're talking about here? And again, to me, that's kind of leveling the playing field too, to make sure that everybody understands what's going on. Michael?
True, my memory is, which is not a very good memory, but my memory is, and Cookie will tell me if this is right. When I got trained, we were told specifically how to handle that, which I don't know what the right answer is, but I can tell you what the policy, to the best of my knowledge, actually still is, which is that when somebody says, are you an attorney, we say something like, the center has trained mediators, some of them are attorneys, and some are not. And our policy is we prefer not to try and talk about whether we are or not attorneys, because our skill levels are all the same, and how we can serve you will be identical. And that's sort of what we were told to say, and only if radically pushed would we say whether we were or weren't an attorney.
But we're also trained though that you never, I mean, if somebody really
pushes you to the wall, you
pushes you,
don't
you
want
gotta answer.
Yeah.
You have to answer honest.
True, but I guess all I'm trying to say, that's my understanding of what the policy used to be. I don't know what the right thing to do is, but that's.
But I have a bigger issue with your credibility if you tell me that we're all exactly the same and our skill levels are all the same than I do whether or not you're an attorney. That to me is less of a genuine, less believable statement than.
Can I just ask you, when you answer the questions you did, when you said did the attorneys never turn back to you and say,
There was no
I
issue.
just asked you whether
No.
you were an attorney?
No, that was it. It satisfied their answer, that answer satisfied their questions. And my reaction to what Michael just said would raises more questions than it answers.
Everybody's skill level isn't the same. What does that mean for CCR?
No, it doesn't. It doesn't.
I think the question is, that's a very evasive answer. And I've worked with attorneys who would zero in and say, so what exactly are you saying?
Yeah.
Yes or no, are you an attorney
Are you able to
right
answer
now?
my
Attorneys aren't trained to do that.
I agree with you.
And most of them are naturally inclined.
I don't know, that's what CCR policy is. That's what I would.
Wait, but no, if the attorney says, no, Michael, answer the question, yes or no, are you an attorney?
Then I'd have to do it.
Okay, then that's what I'm saying, is, but I feel like you would lose a lot by acting in that kind of evasive manner. It would harm rapport.
Because another thing to do is to turn it around on them.
Yeah.
And say, you know, we're all trained, some of us are attorneys, some of us are not. Is it an issue for you whether or not I'm an attorney?
Yeah.
And if so, why?
And you could also
And then
add
if
that
they
it
give you a
doesn't matter.
reason that you think is legitimate, then you can answer.
Is there a policy on this?
Can I toss something out?
What?
This is going to
What's-
confuse things
That's okay.
a lot, and we're going to actually cover it a little bit more later, but this is sort of a... If you are an attorney, you have mandatory reporting requirements for certain types of conduct. Could that not affect what the other party is willing to say to you as an attorney, either the attorney or party, and couldn't that have an overall effect on the mediation? And wouldn't one of the parties wouldn't you be obligated to inform the party of whether you had a duty to report?
Are these things that a non-attorney wouldn't notice?
Oh, you as a non-attorney, you might or might not notice. You probably would notice.
But you don't have to report it.
But you don't have an obligation.
But you're not prevented from reporting it.
Oh, you certainly could. Well, no,
so-
again, because you're saying that the process is confidential, so you cannot.
Okay. So you in fact are, you're right.
But that brings up the whole issue of whether, when CCR attorneys give their opening statement, do they in fact say, I am an attorney, you need to know I will report if I see crime or behavior?
We just asked Allison
Because
before.
without that warning, even if you are an attorney, you're in trouble.
Well, no, because you do have this exception that I may have.
I may have to.
You know, it's like I may have professional mandatory reporting requirements that would require, so that's sort of.
That brings you back to not having to say your attorney.
And Cookie, you mentioned Himmel before. Can you just say 2 sentences? Because I don't know that everybody knows what the Himmel case said for attorneys.
For my understanding is for attorneys, the Himmel case, which actually had nothing to do with mediation, but basically said that if you are an attorney, you're an attorney 24 hours a day, and because of that, if you are aware of the misconduct under the ethical code of conduct, if you're aware of any conduct from another attorney, you have to report that to the Attorney Registration and Disciplinary Commission.
So if you as an attorney see a violation by any other attorney in any context, you have an obligation to report it, and
It's a particular type of violation, but yes. that is-
So it's not cheating at tennis.
We'll talk about that
Okay,
later, if we get to it.
For some of us
And
last
you know
lawyers,
what,
I'm not sure I
this is
recognize
exactly
it.
the kind of discussion we were hoping we'd have tonight, so thank you.
Actually, well, I just want to throw something, not for later, but just for, maybe we can talk about it later. But the thing that I have the most problem with, let's say, for example, if you have a represented party and a pro se party, or the aggressive attorney and the passive or the well-prepared, unprepared, is, you know, doing what I'm supposed to do, but personally feeling uncomfortable. And even though it hasn't crossed any kind of line, and I can't do anything if they have a bad attorney, or I can't, you know, I can do whatever I have to do to level the playing field, but I find it more like leaving and feeling
Bad.
icky, you know? I mean, like, geez, did that person accepted that, you know, their attorney told them to accept this, and, you know, they were depending on their attorney who was a bad attorney. I mean, I don't have that come up very often, but I'm just saying that's the type of thing is just my own personal feeling sort of uncomfortable about it, even though nothing wrong happened. It's just.
And I've been in cases like that too, where it's clear that they gave the case to a junior guy in the firm. He was handed the file on the way out the door, and he comes and he hasn't looked at anything. You know, I may just ask the party more questions, and I may do some different things in reality testing, but I'm with you, Cook. You know, I ride home on the train thinking, you know, that guy just wasted his money because he didn't get what he should have. And
That's what I find hard to process. Yeah, it's just living with that sort of.
but again, there's nothing we can do. Okay, Mark.
Well, we're over an hour into our presentation, and we're at slide 4, and that's perfectly fine. Because Lynn and I, when we set this up, we said this is what we hope happens. We hope we get sidetracked by everyone sharing their experiences and questions, and so we're happy that we're not making the progress that we hope in working through our slides here.
We're just going to talk real fast either way.
Yeah, right. Let's see, I guess for the lawyer mediators, one of the things we talked a little bit about the balance situation. And I have personally been in a mediation, I haven't been in many, but where it seems like because you, the mediator, are an attorney and there's an attorney in the room that you're ganging up on the non-attorney because you're two incredibly smart people who are up against this. I mean, that's the perception that sometimes the people have. And in one particularly bad mediation case where I really think one of the parties was kind of loopy, in all honesty, but she just came right out and said that she was getting very upset and you two attorneys are just ganging up on me. And you know, it really wasn't like that at all. I was just curious from any of the attorneys in the room who have mediated whether you've had experiences where the non-attorney feels like you're ganging up on them.
It's just you.
I guess it wasn't just that one crazy lady. Another thing, when I
Did you tell her to shake off?
that was an interesting case on many levels that I won't talk about tonight, but I'll be happy to. Actually, I might bring her up a little bit further on down. When Drew and I were talking about doing this course, and he asked me about some of my experiences with mediating with lawyers, and the question came up, you know, do you tell them that you're a lawyer? I said, I don't volunteer it, and I said it very, very rarely comes up, and it's almost never an issue. And Drew, surprisingly, said, oh, I've had it come up for me, and it's been an issue on occasions. And I was quite surprised as we shared our experiences that our experiences with lawyers were very different. And you know, one of the things Lynn said about, you know, trying to establish respect, I mean, I always have the impression that Drew would command respect in a mediation. And
Thank you.
I mean, it just doesn't seem like he's kind of the wilting flower that might let an attorney stomp on him, and yet our experiences were quite different with,
Can I be blunt on something?
go for it.
I think some of it is, and I mean, because I've been here a long time, so I started, as I say, when I was 5. I think part of it has nothing to do with your attorney or not attorney, but of looking youthful. I think that's, and let me tell you, eventually you won't. It won't be ever. I wonder though if people, when it's attorneys, that it's really not, are you an attorney, but it's like, gee, you're so young, can you do this? Where personally age has nothing to do with whether you can do this well or not. So, I don't know, I wonder if it's that. You are such a boyish looking, so.
Wow.
No, I do tend to agree with you, because I think my hair works to my advantage for once. I look, like I've got some life experience.
So that's
and
what
some younger people might not look as though they have substantial life experience, even though Drew's led an extreme.
So I bet you it's that more than,
I think it is.
Whether it's attorney or non-attorney, but it's like, no, I know what I'm doing, and I may be, I really am 50, but I just look young.
I actually, I'm not sure that that's quite right. I used to go, I used to go around and watch.
I'm so glad he's here.
We teach together, and that's like.
I used to go around and watch people mediate, and in particular, people who were young and women, when we would discuss the mediation afterwards, would tell me how much it was that the older lawyer types in the mediation didn't respect them, it was hard to deal with them, all kinds of stuff. But me being an observer, sitting there and watching, I didn't see anything. And I think, if I'm right about this, I think the reason has to do with what you said, it has to do with the process. Pretty much all doing the same process. And the person at the head of the table is really running that process. And I think that in and of itself, makes 80% of whatever happens happen, lawyer, non-lawyer.
I haven't had a problem with it from attorneys or from parties yet.
I don't know.
I don't think this is really any different though, any profession, whether it be social worker or therapist or whatever, when somebody asks you a question that doesn't have any, that's about you, that doesn't have anything to do with what's going on, I don't think there's anything wrong with saying, like you did, is that important to you? Why is it important to you? Because it is about you and it doesn't have anything to do with what's going on. And I think a lot of times if you throw it back at them, you find that it really isn't an issue then.
They're
And it
testing.
doesn't come, exactly.
Yeah.
I think the only thing that really is important, though, to remember that as a lawyer mediator, if they push you to a point, they say, I am an attorney, you have to add the part, but I am not acting in that capacity here, I'm not going to be giving any legal advice or legal information, I think once that comes out, you have to follow it up with what you're not going to do.
So I think that probably kind of goes to my other points. Avoid legal jargon, and I've had attorneys try to engage me in, legal discussion about things, and I think you really want to stay away from that. And one other temptation might be if the lawyer uses a legal term and you say, oh, the other party might not understand that, and then you explain the legal term to them. That's not good. What you really want to do is you want to ask the lawyer to explain the legal term in layman's terms, because then it's not like you're siding up with the lawyer against this person who doesn't have a clue what these legal terms mean. So,
Can I actually, just because it's a funny story, I totally agree with you, but I saw something entirely different doing a training down in Champaign. It was a bunch of lawyers and judges who were training. And the lawyer being trained as a mediator suddenly got into a discussion with the lawyer for one side over some legal, exactly what you're saying, some legal, and they got into this big legal argument about the whole thing. And so I said, let's stop them and talk about what just happened. That's, you can't do that, until we use reason. And both of them turned to me and said, that's ridiculous. We are in each other's home, every Friday night talking about legal issues, and we intend to, argue these issues all the time. And the big difference was, it's a big difference between whether it was, here in Chicago, do one thing, but in a much smaller town, people may have very different expectations as to what they're doing in mediation. Part of this is a cultural issue as to how you do it. So I guess, and I totally agree with you, but I'm just saying, there's some cultural issues here that are a little tricky.
Right. Right. I put down no legal advice or legal analysis, but that's no different than our CCR policy about anybody giving advice or an analysis. So, and, don't allow the lawyer party to treat you as, or any party to treat you as a lawyer. Again, that's kind of obvious, but if people know you're a lawyer, they might say, well, you handle these kind of cases. What do you think about my odds of success? Lucky for me, a patent lawyer, my experience as a lawyer doesn't apply to too many of the cases that I do in CCR.
Patty?
While you're on this point, given the fact that we only have 45 minutes left and you may not finish the whole thing, I didn't show up with a whole lot of questions, but I have a big one now, which is, given the fact that I'm a lawyer doing a mediation and I'm doing a disclosure in the front saying, this is confidential and the only reporting requirement I have is if there's a threat of imminent harm. But there's the Himmel case that is going to, because I'm a lawyer all the time, whether or not I'm acting as one in this mediation, I'm now very confused what I'm supposed to do. If I'm supposed to be making some kind of disclosure, so I'd really like to.
We'll talk about it.
Yeah,
It
what it says on the form. I'm sorry. Right, but I think a lot of times they're going to listen, and then and we say, well, this really just reiterates what I've already said. I just want to make sure that you're, and it doesn't. I mean, it's really saying more. Right. So I'm really confused now.
I think your question is, do I have to say I'm a lawyer, or is it sufficient for me to say, I may be somebody who has a reporting obligation, which is sufficient. And that's a good question. I don't think I have an answer. I certainly don't.
I think I would add what it says in the exceptions, just to verbalize that.
And I think that goes to the point of, there may be some merit in people having a copy of this to walk away with if they haven't received it in advance.
I think that's good, but I don't think we've fully explored that issue, to be honest with you.
But the other question I would have is, if you're a social worker, do you have to divulge that? Is
Or
there
a psychologist.
Or a psychologist, do you have to divulge anything different in your opening statement?
Good question.
I would suggest that when I brief mediators and debrief mediators, I tell them, if you have special requirements, you should be saying that to people. And you should be making people aware of that beforehand. So attorneys probably should be saying, if I see any unethical behavior, I have to report it.
See, but I don't think it's trained in the CCR training. I don't think it's addressed.
Well, if the other attorney's a party, or if he's there as an advocate, he has to report it, or she has to report it too. I mean, if there's another participant in there.
But is it true, is it not true that if you said that what's in the statement, attorneys are going to understand what you mean? Non-attorneys aren't going to understand what you mean.
They will if they're the same thing. If for example, if they're a social worker,
right,
and you've said, I may have, again, without saying what you are, I may have some professional mandatory, then I would say it's probably up to them to say.
Right, but you don't have to, like, if you don't want to volunteer that you're attorney in the beginning, but just by saying that, it doesn't necessarily pigeonhole you. I doubt many people are going into mediation kind of saying, well, I am acting unethically, so I better not engage in this process. I think it should, I don't think it would be a big issue.
Yeah, and you don't think using this kind of language is going to raise more questions than answer them? Even if it does, then, I think you have to err on the side that it's important that they know if you're going to do that. Yeah. That you're going to do that. Thank God it doesn't come up too often, but it could, so.
As a social worker in a case with, I'm not, in a commercial case, I'm not going to talk about my child abuse reporting responsibilities, but if there's some chance it could come up, I won't be vague. I'll say, I won't necessarily mention that I'm a social worker. I will talk about serious imminent harm and child abuse or elder abuse concerns, which kind of seems parallel to what Drew says, but without necessarily stating your...
But for example, if you were doing some landlord-tenant case and it came out that the landlord happened to also be a social worker who owned that building, and I don't know, I think in the social worker code you have to report social workers who are doing so, and you found out they were, the tenant says, by the way, I saw that she takes clients in her office and I know she was sleeping with her client or something. I mean, and somehow that comes out, and you would have.
That's not my response. I don't have a,
See, I don't know what your
think I
code
have
says.
a responsibility to report ethical lapses in social workers, but I do have child abuse and elder abuse responsibility.